Thank you, esteemed panelists. So this is going to be interesting panel here. We have a CISO in the hot seat over there. You know, we have a couple of lawyers. We're supposed to either get him in trouble or get him stay out of trouble. You know, and then we have a chief legal counsel and officer, definitely keep him out of trouble, and the company also out of trouble. So this is going to be an interesting topic because I think the regulatory environment has been changing. You know, here in the States in the last year, we've seen the SEC issue a new cybersecurity guidance, which you know, created the obligation for public companies to disclose their top risk on an annual basis, and to also report on material risk, you know, within 4 days of assessment of materiality. And this happened on the heels of the SEC suing SolarWinds Corporation and its CISO Tim Brown on the basis of misleading investors about its cybersecurity practices and known ideas, not on the basis of the cybersecurity rule, but on a different rule. But it created a lot of anxiety. Basically, remember last year we had a session where, show of hands of CISO, half the CISOs were fearful for their jobs. That was a contest a year ago. And let's see if that changed in this past year, and in what ways. The other thing that happened is that companies struggled to define materiality. They basically had these new obligations, and probably is a lot of finger pointing to one another in the company and say, what does this mean? How do you spell it? How do we do this? Who needs to get involved? You know, very open-ended question with there was no manual that the SEC came up with, you know, with this exactly, this is materiality exactly, and who needs to be involved, et cetera. So we had to figure it out as a group. And so many organizations did not have organizational structures to even respond to these new challenges. And so, and the same is happening not just in the US, but it's also happening in Europe. In Europe, very similar legislation is coming to light with NIS2 and DORA that has very similar reporting requirements in the case of incidents, very similar requirements to be transparent about your risk management practice. Actually, in some cases, even more stringent obligation to have an adequate risk management program. In the US, at least the SEC said, you can suck as long as you are public about it. You know, just be transparent so that investors can make sound decisions about what to invest and what not. So we're gonna dive into these topics. So I'm gonna start with Dave first. So Dave, you were the former also head of the enforcement unit at the SEC. And you know, the rule has been in effect, you know, almost a year. And I want to ask you is like, what did we learn since, you know, and what did we learn in the last year? And so, any clarity in our minds on how to tackle this rule and what does it mean in terms of CISO liability specifically?
Sure. First of all, thank you very much. Really happy to be here. And this is my first public appearance where I don't have to disclaim that the things I'm about to tell you are things you shouldn't listen to. So it's a treat for me. It's great to be here. In terms of things we have learned in the last year, I think there are a few. One, I think last year there was a lot of concern among CISOs about the prospect of individual liability and the thought that this new rule might trigger an avalanche of enforcement and regulatory oversight that's materially different than what has come before. I think a year on, that has not manifested, that there really have not been additional cases where individuals have been named as defendants in the context of cyber from the SEC. There haven't even been any enforcement actions brought under this new rule. So the sense I have from the outside is that the SEC, like industry, like all of you, are taking a measured response to the rule, trying to get it right, iterating and trying to improve, and then trying to step back and take a look at where things stand. One thing that surprised me after the rule was brought into effect, I knew it was going to, or I expected it would increase the frequency with which companies would report using Form 8K a cyber incident. I was surprised that so many of those early 8Ks included statements to the effect that we're telling our investors this and we're telling the SEC this, but we don't think it is financially or operationally material. And that, in my mind, is sort of an interesting phenomenon I hadn't seen before. We're basically filing defensive Form 8Ks saying, SEC, you haven't given us enough guidance. We don't really know where the line is. And so out of an abundance of caution, we want to be out front telling people we're not trying to hide the ball. We're just not sure that based on our own internal analysis, this reaches materiality, but we recognize mileage may vary. The SEC may view it differently. We just want to be out front and talking about it. In May, the director of the Division of Corporation Finance, who owns the rule, came out and said, actually, guys, Item 1.05 in Form 8K is specifically designed for material cyber events. And so if you're trying to tell the world about something that's not a material cyber event, maybe don't use this particular section, put it in the notes, put it in a different part of the form. But that's the goal here, is for everyone to take more time to do a more measured analysis. A lot of the Form 8Ks were being filed within a week of the initial incident, and I think that took the SEC by surprise, at least based on the Director of Corporation Finance's statement, where he seemed to be suggesting more time might be helpful to allow companies to come to a more fulsome materiality conclusion and then being able to decide whether or not an 8K was necessary.
Thank you. So Mark, you probably ask yourself as well, what does this mean for me? And you've probably seen your company react to it. So how do you guys react, and both you personally and the company, to the issuance of the rule?
Yeah, I think, going back a year and a half, because the request for comments came out a year and a half ago, almost 2 years ago. And so that build up to that December timeframe, I think some of the larger organizations who especially started in a compliance governance, they had a lot of process, they had a lot of paperwork. Sometimes those programs struggle in the tactical execution of what does this actually mean. And so a lot of the larger organizations, they had some good things in place, they just needed to tweak that. From a Victoria's Secret standpoint, we did some minor revisions on what it is that we were looking at. We added a materiality section in our IR playbook, right? So that we were consistent in addressing some calculations and that process of determining materiality. We went and utilized a service that would collect all the 8Ks. So all the 8Ks that we all file in here, my team looks at them along with our financial and legal teams, and we look and see what does our wording look like, what does their wording look like, should we change anything, are we kind of moving as a herd. One thing I've learned about the legal community, it moves as a herd, right? And if you're outside that herd, you get eaten very quickly. So we want to be in that herd. My words, none of these, right? So my words. We also took that materiality that we generally had an understanding of. One of the first things that I always do when I come to organizations, I sit down with finance, I sit down with legal, I sit down with audit, and I want a materiality number. What is our number? And it's not that cut and dry, it's not that black and white, but we were moving into an area that was a little bit gray, right? So traditionally, when you talk about plant and people and power, and there is an asset that costs this and it's valued at this, well, this cyber world is really challenging, right? What may look today as an incident, in 3 weeks as it unfolds, that may look very, very different, right? So whether it's an incident, whether it's a breach, whether it's a crisis. And so that was really where we spent a lot of our time. So we took that materiality number and we started to overlay some of our top incidents or breach kind of scenarios on top of that. So our team, we mapped the top 13, right, for a reason, right? 13 is always a good looking number. So we mapped our 13 top risks, and we start driving down what that looks like from a materiality standpoint. Those were kind of some minor tweaks that we just kind of backed into. The largest change that we made was I asked to be part of the disclosure committee. I've always felt like I've had a good communication around cyber events or 10Ks that we needed to have wording on, but from a formality of being part of that disclosure committee, After some conversations, that was the big change that we made. So whether it's cyber, whether it's anything that we deal with from an 8K standpoint, I'm part of that group now.
Wonderful. And on a personal basis, you have D&O insurance?
I do, yes. And so that was another thing that I just confirmed. So being indemnified as part of that D&O insurance is really important. I also went out and talked to got some personal counsel and with the help of our legal counsel, but everything panned out, and there was a lot of, I don't want to say worry, there was a lot of questioning for not. I mean, there's liability in everything that, if you have a C in front of your title at a publicly traded company, there's liability there, regardless, right? We asked our external counsel to go, who handles breach response incidents, we asked them to go back, they went back 18 months and run what their incidents look like in comparison to the SEC, the materiality disclosure. They did 288 incident responses. Only 3 of them would have risen to the level of disclosure, right? So not saying that it's not gonna happen, not saying that it cannot happen, but for as much as our industry has discussed it, it's a lot of talk for a really small proportion of what our peers and some of the companies are going through, right? And I think that knee-jerk reaction that David was talking about was because of, we're going to dump the kitchen sink, and then everyone is going to be open, everyone is going to be knowledgeable and understanding of what it is that we're doing.
Thank you for that. Kaitlin, it seems like Mark is ahead of the curve, but what advice would you have for CISOs to, how should they be working with a legal counsel in ensuring that the company abides by the regulatory requirements, you know? So you've probably seen, you've been also a practitioner in a company, you've probably seen this firsthand. Yeah.
That's right, thank you, and thank you for having us. I mean, the short answer is that CISOs and legal counsel, in-house legal counsel, if you have it, should be very in sync. There should be a trust element to your relationship. There really should be, ideally, an ongoing dialogue with your CISO. And as you mentioned, I was in-house prior to joining Goodwin Proctor. I was the chief legal officer at Prudential Financial. And so I oversaw the cybersecurity program as well as data privacy and AI. And I think my closest colleague was the CISO and the deputy CISO at Prudential Financial. We spoke every day, and the benefit to that is that you really gain insight into the risks that are concerning your information security department as legal counsel. And then your information security department gets an understanding of what your what the legal counsel's concerns are, and awareness of the regulatory obligations that arise in the context of cybersecurity. So that partnership is critical. So building trust and having an understanding and awareness of the other's field is a really important piece of this. And with respect to SEC disclosure as well as other state regulatory disclosure requirements in the context of cybersecurity, time is almost always of the essence. Even when there's certain, like the trigger may not start until you actually make a determination, you're expected by the SEC and also just by industry standard to be assessing incidents for reporting obligations with undue delay, without delay. And so if you don't have that ongoing dialogue and that level and that trust between your legal counsel and your CISO, that will inevitably delay your ability to make assessments. So I really think that is the sort of the crux of how you should be working with your CISO, or how legal counsel should be working with the CISO, is just sort of in tandem.
Can I add two
Sure.
points to that? So in addition, I agree with everything you said. I think in addition, there's a value in having a shared vocabulary, which isn't always intuitive for attorneys when they're being exposed to technical issues. And so having counsel who understands the language you're using and can use it back to you and can second voice what you're telling to other members of the executive group and the board is really valuable. And then second, the places where the SEC has been most active in enforcement with public companies has been places where there have been information breakdowns, often between the cyber function and the folks who are out talking to shareholders. And so having a trusted attorney as part of your cyber team and cyber response can be really valuable because it decreases the odds of having that kind of information breakdown that can lead to problems.
Yeah.
Yeah, I mean, I could just add to that. I mean, I'm the general counsel for the company, and near the end of last year into this year, the CEO, CTO, and I got together, and we actually we moved the CISO under me, right? So I'm not and that was for a lot of reasons. Some of what we're talking about today, but also it's because of some of the priorities that we were trying to do within the company. But that would not have been able to happen unless I'd already built up the relationship with the CISO. So when we hired the CISO 5 years ago, I was involved in the hiring process. And so I would say if you're the CISO, and you're not having those conversations, or if the general counsel or a member of their team is not reaching out to you to find, learn about this, learn what's going on, learn about the technology, learn about the people and the process and the solutions you're using, I think you've got to raise that, because that's unfortunately as a lawyer, that's what we end up doing.
Yeah, I have a question here because I heard this in many companies, not many, some companies, where they don't have such a great consensus among the general counsel and the CISO. Unscripted questions. So I heard from CISO like, listen, I want to disclose. The CISO says, I know of some risks.
Yeah.
I think we should disclose it. And the general counsel may tell them, I'd rather not know about it so we don't have to disclose it. I know you wouldn't do it. But how should we handle this? Because this happens in real companies. I mean, I know some public companies where this debate is going on.
Yeah, well, it's a difficult. The question about whether to disclose is not just an SEC issue, right? So we operate in over 20 countries in the world. We have fiber broadband and mobile networks. So there are also some of the companies out there also have to deal with local regulators. Mentioned it. Privacy concerns and things like that. So it becomes a very delicate balance, right? Because we also have customers, right, who we may not want to alert right away to. It's not because we don't want them to know, because I've seen it from CEOs have come out early and said something, and it hasn't ended well because they didn't have all the facts, right? And other times CEOs waited, and that didn't end well. So there's a delicate balance there, and what the CISO and the GC and probably the CFO to a certain extent, what they should be talking about is like, they should be looking at all of those things because there's a commercial aspect to it. But at the end of the day, it is the lawyer's responsibility to make that decision, and that's, Mark was mentioning liability. That ultimately, whether they report or not, it's the lawyer's obligation to protect the company and all the stakeholders, and there's a lot of different variables in play. The key to me here is, one, you have the open conversation about it, okay, and no facts are hidden from the key people being made, and you have a consistent process that you can follow. Mark mentioned the IRP. We adopted our IRP for this to make sure that we have a communications now committee under the IRP or group, right? That includes both the comms people, but also my head of SEC reporting, who knows materiality better than most. So, it's really, to me, just ongoing communication than anything else.
Thank you.
It's a really interesting question, and I think John hit something. He kind of glazed over it right there, but I think, in my opinion, the biggest risk to all of our organizations is that we don't communicate risk so that everyone understands the posture. And so it is our job, and if it is our job to verbalize that, to visualize that, to drive it to ground, and to get people who are at a level that can do something about it to acknowledge. or understand, right? And sometimes, I don't know any security professional that when you say, you know what, we analyzed it, we calculated it, we communicated it, it got to the audit committee, it got to the board, the CEO said this is really important, but it's priority number 4 right now, we will get to it, we've got a plan, we've got some mitigating, remediation, controls in place. I feel like every security professional, protection-minded individual, risk professional will look and nod their head and say, you know what, if we could do that every single time, that would be sufficient. Now, if they just bury it and never act like it's there, that's a different discussion. Personally, I haven't been involved with those kind of executives. So the executives that I've been involved in care about the product, they care about their customers, they care about doing the right thing. And so most, in my 25 years of doing this, not as a CISO, only 8 years as a CISO in a couple different companies, it falls back on us and our communication, generally speaking. There's always an outlier out there, right? And do we take that ground when we need to take that ground, or do we back off because someone might have a different title or a different responsibility in the business? A lot of it comes back to us and how we communicate, the lack of how we communicate, the ineffectiveness of how we communicate. And so I'm encouraged by that, because that puts more onus on us driving the right outcomes.
No, thank you. We heard the same thing in the previous panel, where it said CISO should communicate, be transparent. Decision will be made, document the decision as well, because at some point somebody may ask questions, and we want to know what happened in that moment. So I'm going to ask a question now to David. So David, we're in DC. The Supreme Court recently ruled on the Loper-Bright versus Raimondo case, and maybe you can tell us a bit more what that case was about, and what effect do you think it will have on CISO liability? Will it increase or decrease?
Excellent. So yeah, happy to speak on that. So Loper-Bright analyzed and considered a prior precedent out of the Supreme Court called Chevron that was part of the Chevron doctrine, where basically, that was back in the 80s, and the Supreme Court was looking at an issue, I think it was in front of the EPA, and saying, us 9 judges are smart and wise and reasonable, but we're not chemical experts or pollutant experts. The EPA are chemical and pollutant experts, and therefore we are inclined to defer and give an agency who is specializing in a particular area a degree of leeway in making decisions, making rulemakings, and interpreting those rules. Loper-Bright sort of reversed that back and said, actually, we're pretty smart judges. Like, we got this. We don't need to worry so much about agencies being smarter than us or having better decision-making than us. We also are capable of substituting our judgment instead of an agency's. And so I think the likely outcome are SEC, and that decision came after I left the SEC, so I feel more comfortable talking about how the SEC may react to it. I expect the SEC is going to be a little reluctant, and that's part of just kind of a general repositioning of where the administrative state fits in kind of the legal framework. I think they're going to be reluctant to be put in positions where previously they might have gotten deference, and now a court is going to be using its own fresh eyes to come to a conclusion as to what the right outcome is, what was reasonable behavior. Where the SEC does not want to be is making business judgment type second guesses of decisions that companies made in the context of cyber or other technical issues. Like, there's an idea that businesses, as long as they're disclosing publicly in a way that's consistent with their obligations to shareholders, have latitude in deciding how they're going to run and operate their businesses. And I think that will extend to cyber, and I think Loper-Bright will support that. And so not having a program when you say you do is a major problem. Having that problem operate a little differently than maybe the SEC investigator would have liked to operate it, less likely to get you into trouble today than it was before Loper-Bright.
Very good, thank you. Now, there's another question for John. Can you tell us a little bit, what is the process you went through when you had to do your first 10K? And so, new rule comes in effect. Okay, now we need to do this.
Yeah. I mean, I've been trying for years to reduce the amount of disclosure in our 10K generally, but it always seems like you can only add and you can't take away. And by the way, I say that also for people to remember, once something goes into the 10K or a public document like that, it is very hard to take it out. So if you are working with the lawyers in preparing disclosure from 10K, just remember that it's going to go in, it's probably going to stay there for a while. But, you know, Mark is absolutely right. Lawyers, we work off of precedent, whether I was doing a deal or doing disclosure, whatever it is, the first thing I do or ask my people to do is, what are the last 10 filings or what did they say? So we started and looked at what other people were doing, right? What were they covering? What areas were they covering? How much depth were they going into? And then we use that as just a framework for questions. So we have annual D&O questionnaires, right, for our directors and executive officers. We added to our executive officers a question about cyber and their experience and expertise in cyber so that we could possibly add that in. We then talked to, obviously engaged with the CISO and his team, as well as other members of the technology team. At that time, the CISO was under the CTO. And then had a draft. The person that works for me on SEC work prepared a draft. And then our privacy team reviewed it. I reviewed it 3 times. My head of compliance reviewed it. The CTO reviewed it. And ultimately, the CEO reviewed it as well, who had an engineering background as well. So it was, and then ultimately it went through our disclosure committee, of course. But that was, and now we have that, you know, that disclosure. I was actually surprised at the consistency at which if you look at the disclosure, it was pretty consistent on how what people were covering, the depth or lack thereof that people were going into, which is not inconsistent with my experience when new rules come out. It becomes pretty rote, and you don't get into a lot of detail until, you know, something really happens or is transformative. So, you know, that was the process.
Did you had any reference to how you deal with materiality or not? You didn't.
No, I mean, other than a reference to, I mean, our approach to materiality is the same as we would approach anything else, right? Mark referred to a number. It always starts with a number. I don't give people my number, just not that, because I feel like at the end of the day, the decision on what is material for SEC purposes, really, ultimately it's the CEO, but ultimately it's 2 people in the company, in my opinion, that makes that decision. That's me and the CFO, right? So general counsel and CFO. They're the ones with the best knowledge, experience over the business, the impact on the financials, and are best positioned to make that assessment. So, you know, we don't really approach it differently. There are other questions. When a cyber incident comes up, there are other questions that I would ask, or I ask my team to ask, and we put into playbooks, that I wouldn't ask in a different situation, right? So what's the impact here? Do we have data privacy breaches because we're a telecoms operator? You know, is this going to have to be disclosed somewhere else? How many people are impacted? What of our systems are? Is this a vendor? Like, did we have a vendor impact? Because that's one of the things I learned, and CISO should understand this as well. It's not just your systems, but if you're relying on a third-party system and theirs goes down, so the famous CrowdStrike one, you know, they called me and said, hey, this is a problem. This could be an SEC issue for us. I'm like, why? It's not our system. It's like, well, we rely on CrowdStrike. So, you know, you have to ask other layers of questions, but the ultimate determination of materiality will still kind of come down to the same factors I always look at.
Talking about incidents, Kaitlin, can you tell us what good and bad looks like now in 8Ks? You know, incident hits, and what you think, you know, is a no-no, and what actually should be the right thing to do.
Yeah, I think absolutely. Oh, now it's definitely working. Thank you. I apologize if you did not hear me before, but what I was saying before, and I actually did want to mention really quickly, is that clearly a common thread is that communication between legal counsel and CISO is key. So if you didn't hear my earlier segment, that was the gist of it in fewer words. So, but often, in fact, like legal counsel acts as like a translator. So when you were saying, you know, good communication is so important, well, utilize your legal counsel to aid in that regard, because that's a key skill of legal counsel in cybersecurity. But getting back to 8Ks, so rather than frame them in terms of good and bad, what I would say with respect to the 8K requirement is that the requirement is disclosure, as we know, to investors, so they can assess risk with respect to their investments. So you clearly need to address the rules requirements for what needs to go into an 8K. And so you would need to describe the material incident, the material aspects of the incident, and then the material impact to your company. But what is really key is taking into consideration the guidance that has come out from the SEC that David referred to earlier in this segment, which is that you should have a process in place in advance to consider whether, okay, is this a material incident that must be disclosed pursuant to the 8K requirement under a specific item, or rather, is this something that we feel we should disclose, and we are therefore making a voluntary disclosure? And whether or not your disclosure is required or voluntary will impact whether you've made sort of a quote-unquote good disclosure, because the SEC really wants to avoid investor confusion. And so if you're voluntarily disclosing something under the parameters which were set forth for material required disclosures, that will trip up the confusion that the SEC wants to avoid. So the key here is advanced planning, working with your legal counsel in advance to have a materiality assessment process that works in connection with your IRP and has the appropriate escalation procedures to bump something up to be assessed for materiality, and then also in advance takes into account, is this really something that we want to disclose because it's required to be disclosed, or because we feel it should be, and therefore it's a voluntary disclosure.
I know just one other thing about the communication there, because there is a part of the rule that allows you to delay under certain circumstances, including if you get an order from the Attorney General of the United States. That kind of freaked people out in the beginning. Mm-hmm. David might have a view on that, but the only reason why I bring this up here to the CISOs is one of the preparation things is having, if you're in the U.S., right, that interlock with the attorney's office, right, whether it's in your local state or up into the U.S. government. So when something happens and you want to rely on that, they know you, and you can get that ruling pretty quickly, which, by the way, the reason why the 8K freaked me out, freaked everybody out, is because it compressed your time. Previously, you had a lot of time, and everyone knows these cyber incidents, you learn a lot in the first 24 hours, but it's days and weeks where you're constantly going. So if you're able to secure that time for the CEO and everybody, it really kind of ramps down the pressure, at least on a disclosure perspective. So that's an important thing to talk to your lawyer about as well, and make sure you have that contact.
Yeah, and about that, the Department of Justice delegated that authority down from the Attorney General down to, I think, Deputy Attorney General, or even an Assistant Deputy Attorney General. And so it's not, you have to get to Merrick Garland to get it done, but they are infrequently granted. And the other thing is, I think that it's a separate track, not a alternate track as far as talking to criminal law enforcement. That it's important from the FBI's perspective and Department of Justice perspective that they understand who is acting on our companies and our commercial interests, and who is attempting to penetrate our networks, and providing that information benefits our ability to collectively protect ourselves. And I've seen people say, well, if I tell the FBI to then have to tell the SEC, they're really they're separate tracks, separate inquiries, and I don't believe that information is changing hands between the two agencies.
We have a question from the audience. By the way, everybody feel free to get questions forwarded through the app. So the question is, given both regulatory and litigation risks, should fair assessments be done under privilege in anticipation of litigation? By the way, while they're thinking about it, I also want to say when people say fair assessment, of course, assessing the risk. For the record, a year ago, the Fair Institute worked on a model and published a model called the Fair Materiality Assessment Model. It allows you to break down the forms of risk. And it's interesting that I think there's just a plug here. Let me see if I can make this work. Can we move the slides forward, please? A couple of slides forward. This is not working. Okay, yeah, so it's interesting to see that some of the 10Ks out there starting to reference the use of FAIR as part of their method to assess, risk, and at least on a periodic basis, But, so how would you respond to this question to the audience?
It's a really challenging question that I think without a lot more facts would be hard to give great advice about. I mean, the two considerations that hit me off the bat are, one, are you in a position where you really want to be able to protect this information under the cloak of privilege? And if so, working with your counsel to consider how this might be conducted in anticipation of possible litigation is more likely to provide privilege or work product protection, which can be good. Unfortunately, being able to show the FAIR methodology you underwent and how you made your trade-off decisions about where you're going to prioritize resources can be really helpful when you're trying to explain to a regulator, you did the best you could, you still got breached because you've got very motivated opponents who are looking to try and get into your network. And if that is considered privilege or work product protected and you share it with the government, you've now lost that protection, and often those waivers aren't selective as to the party to whom you shared it. It is a broad waiver and anybody else will then have access to it. Not normally a problem, but if you've built your system for secrecy and suddenly that secrecy is gone, it may raise other considerations.
No, wonderful, thank you.
Absolutely not. So I want everyone to know that we do a consistent analysis when we assess risk. I want everyone to know that we have a third party, multiple third parties that come in and do our security assessments. Confidential, of course. I mean, no one's going to know what the outcome of that is unless something happens. But from a privilege standpoint, absolutely not. First of all, I don't think you can keep privilege in a large organization, doing these kind of risk assessments that might have 40 to 60 people involved in them. But 100%, I want as many people to know about that process and the consistency of the process and how we communicate that process. So 100% agree with.
Yeah, I mean, I think there's the program either earlier or tomorrow about this in the broader concept of your enterprise risk management. I mean, it's really comes as part of that. So it shouldn't really be treated any differently than the way you would treat any other risk that you're bringing up in front of the audit committee or the board. And that's why you have skilled lawyers, you have a lot of people looking at this stuff, because there are things in there that you could extract or say differently that will be better for you rather than just holding it out as privilege. Because by the way, my experience is when the government asks for it, I have very little success in keeping privilege when the government asks for it. It's a different thing when you're in a shareholder litigation and things like that. That's a different scenario. But yeah. So.
Well, thank you for your insight. We're 1 minute away. I'm trying to summarize now what we discussed. I think in terms of CISO liability, definitely let's make sure that for those who are in that position, make sure you understand your officer's obligation, get insurance, make sure you're covered under D&O insurance. As we assess risks, make sure that you communicate to all the parties. And what I learned here is seems like in the last year, this collaboration between legal counsel and the CISO is absolutely necessary and paramount to make sure that the company makes sound decisions and communicates appropriately. And I think the big relief, sigh of relief, if I could amplify some of the sentiments probably heard from some of you, is that DCC is not coming after the CISOs for the sake of it, and they will not call foot fault. I play tennis. They're going to foot fault. They're going to come after you if we purposely misrepresent, say what's been going on, especially very severe issues on the cybersecurity side, while publicly saying the opposite. And so that's something that, and the last is as a CISO also, as we make those decisions, make sure you also do document all the decision making, because it's very important at some point, if something happens, question will be asked, and to understand what was the rationale that was followed in terms of making a decision in disclosing and acting upon an incident. Well, thank you for your comments, your insights, and hopefully that you found this informative. And I'm going to call Christoph back to the podium. Thank you to our panelists.
Great job.